Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer. I am an extension legal specialist here in the Department of Ag and Resource Economics at the University of Maryland, and we are back with new episodes. Sorry for the delay. I had a lot of meetings and traveled a lot over the past 2 months, so it's been hard to put together episodes while you're traveling and not at home or not in your office where you can do this. But I'm happy to be back doing this. And one thing that's changed a little bit since we did this last is now, as a part of this, we are now one of the partner podcasts through the Maryland State Bar Association's on-air legal lab. So I will include some information in the show notes for that as well. So you can check out some of the other good podcasts there as well. So as we're moving forward with this today, I kind of want to go back and talk about some of the things I've been writing about over the past few months. And one of those is looking at when do we need to set up receiverships in some cases when family members, don't put together the best estate plans for a farm and then create some other issues that could develop over time. So like I said many times before, unfortunately, the process of developing a estate plan that works for families often requires those family members to communicate freely on goals and other sensitive topics. At times, disputes might arise, especially when we see property co-owned and parties do not agree on how to manage that property. In such cases, the court might appoint a receiver to manage the property. We're going to look at a decision out of Nebraska that highlights when estate planning can lead to this and the conflicts that can arise. This decision is in said versus said, and I'll put in the show notes the case citation for those interested in this. So in this decision, it involves three parties holding a fractional interest in a life estate. And before we move on, I need to explain what a life estate is, probably for those that are not familiar with it. A life estate exists for the duration of a specified person's life. In this decision, we have Rita and Judy Raymer, they're children of the deceased. And then we have Beverly, who's the wife of the deceased. They were each granted a fractional interest in a life estate in agricultural land. From the court opinion, it is unclear if Beverly was a mother or stepmother to Rita and Judy. We can just speculate on what that was. Beverly could not agree with Judy and Rita on the management of the agricultural land. Beverly filed a court action alleging that she had not received her share of the income from the land. In 2018, Beverly also argued that she had not received any documentation regarding the income, expenses, and assets associated with this agricultural land. In her action, she requested that a receiver be appointed to manage the property and help them come to an agreement. After an ineffective mediation session between the parties, the court appointed a receiver in 2019. Later in 2020, Rita and Judy requested Beverly to contribute to maintenance and repairs to ensure that the land remained suitable for farming. The court rejected this request, finding that the evidence did not show the work was needed. The receiver performed the duties in 2020 and requested instructions for 2021. Rita or Judy had never filed a motion asking the court to discharge the receiver at this point. It's important to remember that. Instead, the court gave the receiver instructions for 2021. Rita and Judy filed an appeal on the court's order providing instructions for the receiver for 2021. So before we get started, let's talk about what is a receivership. A receivership is basically, or receiver is a disinterested person the court can appoint in certain situations, such as when we have this disagreement between joint owners in property. The court often appoints these receivers as an equitable remedy to help preserve the property. If the property owner, the joint owners can't agree, we need somebody who can step in and make decisions to help manage the property, preserve it, and maintain it. Here we're dealing with a life estate. So at the end of the person's life that it's associated with, it'll transfer to other people. So we have to maintain that property to maintain the what it's worth so it can move to the next party and we don't get in trouble for waste and other things associated with that. So when we have co-owners that can't agree on managing the property, for example, the court might appoint a receiver to act as a disinterested party who will work to preserve the property. In that example, the receiver operating on instructions for the court can ensure the tenants receive the best rental rate, and repairs are made needed to preserve the property. So, and I say tenants receive the best rental rate. It's going to be, in the end, the landlord gets the best rental rate too, and it's a fair rental rate. So now let's move back to the court's opinion. On appeal, basically, Rita and Judy argue that the trial court erred in appointing the receiver for 2021 because no party had requested the appointment of the receiver. The court never determined it was necessary for 2021, and the court never considered their evidence that the conservation work they were requesting earlier was required. The court found that basically all three of these arguments failed because the court did not appoint the receiver in 2021, but appointed it in 2019. In addition, the court found it was too late to attack the 2021 or 2019 appointment because that order had not been appealed in the time frame allowed. So basically, if you wanted to attack the receivership, you had to do it back in 2019 and not wait till 2021. The court also disagreed with arguments made by Judy and Rita that the 2021 appointment of the receiver was flawed based on the evidence of the receiver's motion and not based on Judy, Rita, or Beverly making the motion to do it, and the lack of notice required by the statute in this case. They would have had to have been given notice that a receiver was going to be appointed. The court found that all three parties sought relief through the receiver, so the motion was appropriate. They were working with the receiver. They were already doing it, so the receiver making the motion was okay. In addition, all three parties agreed to participate in the hearing related to the 2021 receiver's instructions, so they received the notice. So by participating in the hearing, they had shown they had actually received notice. So why do we care about all this? Well, I use this case not because of the procedural issues. Most of this case is turning on procedural issues that for a layperson you're not really going to care about. For legal people, they may care, but for lay people, you're not going to care so much about that. But I use it more to highlight the issue of what a receiver is and the times the court may appoint one. For example, parties might give equal shares of the farm to all the children in estate planning. This is going to naturally create conflicts. A receiver might be needed to resolve some of these conflicts. And this may stop a forced sale in some cases. It may not in all cases, but it's out there as something we could look at. Receivers are typically equitable remedies that allow the court slightly more flexibility in resolving disputes. In this case, the parties might find the receiver to be unnecessary, but this receiver is out there to help resolve conflicts and help the parties maintain the property, especially since we are dealing with a life estate situation where we can't typically force a sale and divide up the money that way. We're looking at it from a much different standpoint. So thank you for listening to this episode. If you have any questions for me or topics I should be covering in future episodes, please email me at lgoering@umd.edu, or you can find me on Twitter and Instagram at aglawpaul. Thank you again for listening to this episode. And again, please check out the MSBA's Legal Lab to learn more about some of the other podcasts that are being partnering with MSBA through this new venture. So thank you again for listening and enjoy the rest of your day.